All rise. The Court of Appeal in the Court of the 5th District of the State of Florida is now in session. The Honorable John M. Harris, Judge presiding. All persons having business before this court, draw near, give attention, and you will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
All right, good afternoon. Welcome to oral argument session here at the 5th District Court of Appeal. As Marshall indicated, I'm Judge John Harris. You see other members of the panel with me today, Judge Adrian Soud, and we're very happy to be joined with an associate judge from right here in the 7th Circuit, Judge Lauren Blocker. We have 3 cases on the afternoon docket today. In each case, each side will get 20 minutes for argument. Appellant, you can reserve as much of that time for a rebuttal as you would like. We'll set it default at 5 minutes. If you want anything other than 5 minutes, just please let me know and we'll make those arrangements. We are being recorded today, broadcast on YouTube, just so that you're all aware. And finally, if any of you in the courtroom today have any cell phones, other noise-making devices, please make sure that those are either turned off or silenced at this time, so the proceedings are not interrupted. First case on our docket today is case 24-1843, Kidwell Group versus Citizens Property Insurance. Counsel, when you are ready, you may proceed.
Thank you, Your Honor. Good afternoon. May it please the court. William England here on behalf of the appellant, Kidwell Group, and I'll take the default 5-minute reservation.
You got it.
So the facts of this case are pretty straightforward. Those are not necessarily in dispute. It's the appellant's position that the trial court inappropriately applied the law in derogation of binding precedent that existed at the time. So because the record is pretty straightforward, Kidwell Group provided services to the insured John Fortner. There was an assignment of benefits executed on December 21st, 2021. The assignment of benefits was attached to the complaint and is part of the record. The assignment is not just signed, but it is also subsequently initialed by John Fortner during the estimate section of it. And there is an invoice estimate that is incorporated through specific reference. The specific reference within the assignment of benefits is located at the very bottom of the assignment, and it states that the client and AQA hereby acknowledge that this is an itemized per unit cost estimate invoice has been provided with this contract and is fully incorporated herein. The long and the short of it is my client provided services that involve inspection and preparation of an engineering report and repair plan. It's one quantity. It is one report, one repair plan. That's it. It is plaintiff's position, it's the appellant's position that the one service, the one charge, satisfies the per unit cost estimate requirement of 627.7152 subparagraph 2. There are
When you look at the SafePoint case, is there any material or substantive difference between the language of the assignment agreement and the invoice in this case compared to that SafePoint case?
There is no difference. There's no difference.
So how did the judge, in his order, distinguish SafePoint from this case? I'm having trouble following what he said.
Well, he did not, and specifically looking at the order, and the order on its face does highlight why it needs to be reversed, because when distinguishing, he only addressed the MVP plumbing matter, and that one was a $750 pipe inspection. However, there was no distinction within the order of the SafePoint matter. And I highlighted to the trial court at the time that this assignment is identical. It was executed within the same month of the same year. It was just a few days apart, but a different service. And in the 4th DCA, just to go through, there are 6 primary appellate matters that I'm relying on and addressing here today. 3 of those involve Kidwell. 2 of them involve the exact same assignment language. 1 does not. So to go through the history of it very briefly, you have the air quality experts out of 2022. That was out of the 4th DCA. That set forth that you cannot just have a laundry list of charges or services that you could provide or are available. you have to specify what you're going to do in order to satisfy the per unit cost estimate. We're not asking you to find conflict with that. That's proper. And then you had the total care matter out of the third DCA. That one highlighted that you cannot have a general menu of available services. And in that particular matter, the court also highlighted there's no clarification as to what services were being selected, which rooms were going to be applied to, or whether it's even the same property, whether it's even emergency or non-emergency services. That's not what we have here today. That's not the assignment at issue in this instance. And then the other Kidwell matter that is not the assignment language that we have at issue was the Kidwell versus United Property. That one was a 2022 out of the 4th DCA. And the SafePoint case highlighted why that case does not apply here. Because in that instance, it also had a list of services, but the corresponding invoice was 5 days later. So there is a chronological gap between the assignment, the alleged estimate, and when they got it. That's why those cases are different than what we have. Now let's talk about what we have here. This one is very similar to the MVP plumbing, very similar to the SafePoint matter, as well as the recent Southern Oak matter that came out of the 3rd DCA.
You didn't do a supplemental authority on that case, did you? A little surprising, because it does help you, and it was your firm that did that case. So.
We did reference it in our reply brief, and we did highlight that the 3rd DCA went back and considered that. So that one is in the record once it came apparent, because I believe the order came down in May after the respondent had filed their answer brief, but before our reply brief was due. And so with regards to MVP plumbing, that one is pretty straightforward. It is a $750 charge for a pipe inspection.
They conceded error in Southern Oak, did they not?
Absolutely. In Southern Oak, they did concede error.
Any insight or any thought process you have as to why error would not be conceded here?
I caution any attempt to try to get inside the respondent's head or citizens' heads in this one, because from our perspective, from the appellant's perspective, these are identical, and error should have been confessed as well in this matter, just as it was in the
The incorporation clause is not just substantially similar, it's verbatim.
It is verbatim. It is the same. The only difference in the Southern Oak AOB and the one at issue in this matter is that the charge for the engineering report was $5,000 instead of the $3,000. That's it. That's the only difference. Everything else is verbatim identical. And so not only do we have the MVP plumbing, where the 3rd DCA highlighted in 2023 that a singular charge for a pipe inspection satisfies the per unit cost estimate, but then you also have the SafePoint matter out of the 4th DCA, which was provided to the trial court prior to his ruling. And I highlighted in that particular instance identical language, identical charge, because the SafePoint assignment also had an engineering report, and the charge for that was also $3,000. So that is the closest to being identical as you can to the facts at issue in this particular matter. The court did not necessarily address that in his order, only relying upon the prior 4th DCA ruling out of 2022. Again, it's not for us to get into the head, because the order on its face cites to the binding precedent, cites to the 2023 SafePoint case, and goes against the binding precedent, goes against, at the time, the 4th DCA's binding precedent pursuant to Part OV State applied to the Seminole County trial courts, and they did not comply with it on their face. And then again, subsequently, Kidwell versus Southern Oak, that one was the 410 Southern 3rd, 1277, May 7th of this year. In that one, Southern Oak did concede error. They said this assignment is just like the SafePoint one. However, the 3rd DCA did go on to highlight and provide an analysis that says, yes, we are going to reiterate our holding in MVP plumbing. We agree with the logic and the reasoning out of the 4th DCA in the SafePoint matter, and we agree that a one singular charge for one report satisfies the per unit cost estimate. And so because of that, the trial court abused its discretion, especially at the motion to dismiss stage, when it should take all reasonable inferences in favor of the non-moving party, i.e. the plaintiff, and granted the dismissal with prejudice. Now, to briefly address some of the arguments made in the answer brief, the defendant, the respondent is, the appellee, is asking you to apply a tipsy coachman rule. That does not apply here. The court did not get it right for the wrong reason. The singular issue is identified in paragraph 3 and paragraph 4 of the order that's been appealed, and that is the misapplication of the per unit cost estimate analysis in the case law. Under tipsy coachman, the defendant is trying to bring in a new argument that was not the subject of the prior order. Prior order did not address any pre-suit demand letter requirements. It did not address any subparagraph 9 requirements. That's not an issue in this case, and tipsy coachman does not apply. But even if, in worst case scenario, this court were to agree that, well, you know, there might be an issue with the pre-suit demand, the court still needs to reverse the trial order because, as this court has long held, failure to attach a pre-suit demand letter is not a basis to dismiss the matter with prejudice. It's a fixable error under the rules of civil procedure, and it should be allowed to be fixed on remand. And that's only if the court buys that argument. However, in this instance, we don't need to get there because you have two sister courts, the 3rd DCA and the 4th DCA, that have ruled consistently on an identical assignment of benefits as the one that's before you. And I respectfully proffer that in order to affirm the trial court's ruling, this court would have to certify a conflict with both sister courts, especially on this particular issue. And honestly, I do not believe that they got it wrong. This is not a tiling issue. This is not a shingles issue where you have to have a certain amount of tiles to fill a room, square footage, all that. You're not dealing with that. We did not bill per hour. The customer executed this assignment to hire us to prepare an engineering report and a repair plan by a licensed engineer in the state of Florida that would comply with the building requirements. And specifically of importance, the very first paragraph highlights that of the assignment. It states that the client should provide a copy of any report prepared by AQA to its repair contractors to ensure a complete and proper repair of the damage to the subject property and obtain any necessary building permits. So again, this is not where you have to count up shingles. This is not where you have to count up tiles. This is not where you have to count square foot. It was a singular charge, singular service that was provided. And we fully complied with the requirements of 627.7152. And so for those reasons, I asked the court to reverse the trial court's ruling. And then alternatively, if the court does not necessarily agree or see eye to eye with me on that particular aspect, I would ask that you at least reverse it because a dismissal with prejudice is not allowable under the law. Not when there's a chance to fix it if there is a tipsy coachman analysis. I will reserve the rest of my time if that's all right, Your Honor.
Very good. Okay, thank you, sir.
Good afternoon. Maureen Piercy on behalf of the Appellee Citizens Property Insurance Corporation. I'm going to try to move this down. I would like to address first the tipsy coachman to get that out of the way. First of all, a request was first made via the reply brief for a remand with leave to amend. That was never raised below. There's no record of that having ever been raised, so that hasn't been preserved.
Pre-suit notice issue in front of the trial court?
It was raised in citizens' motion, and excuse me while I get my reading glasses. It was raised initially, and I realize this isn't our main argument, but it was raised initially in June 1st of 2023, and it was raised in the amended motion and the second amended motion. So the argument was presented that the notice of intent wasn't complied with. There was nothing attached to the complaint showing that, and there was a generic pleading.
Well, the pleading does say on that issue that all conditions precedent have been met or satisfied or otherwise waived or something like that, right?
There
On a
is-
motion to dismiss, we accept that as true.
There is a...
Let's dismiss it for not complying with something when they said they've complied with it.
there is a generic statement and nothing more. And on this record, we don't have any response from the plaintiff on that. There was no written response to the motions other than the first motion to dismiss, which did not raise these issues, and there's no record of the hearing transcript. So the only thing we have is the order.
Of
I'm
the
sorry.
rehearing.
Yes, correct, or of any other hearing.
Was this raised in the rehearing? Was this point argued, if we don't have a transcript, which of
Correct.
course has an effect on the appeal potentially,
Correct.
was this raised during argument on the rehearing?
So I can only tell you what's in the order, just as we don't have any transcript of any hearing at this point. But preservation is raised and presented to the court. It was presented in citizens' papers, and in the reply brief, there was a statement made that it wasn't raised at the hearing. Well, we don't have that in the record, so we can't make that representation to you, nor can they make the representation that it wasn't made, and that's the problem. But that it was presented, the argument was made, the statute was cited, and if the court ruled on one of two issues, it wasn't obligated to rule on the second one. It wasn't obligated to put in that record. And it's the appellant's burden to bring forward the fact that they raised an objection to that and preserved it, and that they did not do. If the court doesn't have anything else on the tipsy coachman, I'd like to get to really our main issue here, which is the estimate. Now, again, we come back to the issue of there's nothing in the record. The only thing we...
The Safe Point case is on point, right? The language there is identical to this case.
The Safe Point case does have an estimate that has the same language as this one.
Okay, and that was the only district opinion at the time on this issue.
That's correct. And both sides,
How does a county court judge that's sitting in the 5th District then just disregard case law directly on point? He can disagree with it, but he still has to follow it, doesn't he?
Your Honor, that case, I agree that a trial court is bound by any appellate court if there is no conflicting rule from its own appellate court. But both sides actually cited Safe Point. And one of the things that I think is interesting is in Safe Point, they talked about the engineering report and repair plan, quantity one, and a price. But there's no discussion of the language in the report, in the estimate that defines forensic engineering. And that argument, that was addressed in Southern Oak, which I'll get to in a second.
Don't they include a copy of the assignment and it's identical and it does include a definition of engineering?
It's in there, but it's not discussed in Safe Point. There's no discussion of that language. So we don't know, because again, we're stuck with whatever's in the opinion. The court doesn't talk about that forensic engineering definition. And the interesting thing about that is, so that's
You're saying
not...
the court, the 4th District?
I'm sorry?
I'm sorry, I just want to make sure I understand what you're distinguishing. You're saying
Safe
that
Point.
that the Kidwell Group versus Safe Point, the 4th DCA case, you're saying that they didn't discuss the definition language for a forensic engineering report?
Correct. It's, the document is in the appendix to the opinion, but there's no discussion of that language itself in the opinion.
Regardless, wouldn't the holding that it meets the requirement for a itemized per unit cost estimate be binding?
It's finding on the estimate complying would be binding, but hear me out on this. If an argument was never presented that there's an ambiguity because of this language, then the court hasn't addressed that, correct? And that's what we're saying. So then Southern Oaks comes out after Safe Point. And also, just as an aside, there's nothing indicating that that argument was presented below by the appellant that Safe Point was even binding. So both sides actually cited the case to the
Black
court.
letter law.
I'm sorry?
That's black letter law. If there is an opinion from a district court where outside of the district the trial court may be sitting in, and there's nothing from the district where the trial court sits, that precedent from the sister district court binds. That's not in dispute.
Well, as I said, both sides brought the case to the court's attention, and citizens' argument was twofold. One, the forensic engineering definition is very broad, and when you look at engineering report, and we don't even know what that means. We don't know if there was structural damage. We don't know if there was water damage. We don't know what this report was intended to address, because all we know is that a covered loss was pled. That could mean anything. So if you look at the definition of forensic engineering, which is extremely broad, that's where the argument comes in that it's not itemized to the point where the consumer, which is the policyholder, can understand what they're assigning and what service they're receiving.
Why wouldn't the appropriate action for the trial court be then to say, we don't know if the 4th DCA considered this definition to be vague, but I'm bound by it, and then you could take it up on appeal if you chose to?
Absolutely, that could have been done, but again, I don't have a record of what happened at that hearing. So all I have is the order, which the court says that it found in favor of citizens on it not complying.
Well, the order, and I have a copy of the order, and I want to come back to the assignment in just a minute. The order essentially, we do not have a transcript that has been thoroughly discussed. The order does give in paragraph 2, briefly describes what the defendant below, which would be your client, right?
Correct.
Defendant below argued, and the cases that were cited. Paragraph 3 talks about what the plaintiff argued, and briefly summarizes in the last sentence the defendant's response and distinguishing of the cases. Paragraph 4, the court states its conclusion, plaintiff's assignment agreement fails to contain the required itemized per unit cost estimate as part of the assignment agreement or otherwise sufficiently described as to incorporate same in the assignment agreement. That is the sum total of the court's finding. There's not an indication what was fatally flawed as to what the court determined in light. And I will tell you, I came into the argument today scratching my head, and I think you've started to answer what your position is. And I appreciate you representing your client, but I am left still scratching my head after listening to it. I have no understanding how the trial judge, and all three of us were trial judges, I have no understanding how the trial judge gets around the 4th DCA case, the SafePoint case. I don't, if I were sitting in a hearing room in the trial court and this was in front of me and that case, again, the assignment provision, the incorporation clause is verbatim the exact same. You would agree with that?
Absolutely.
So one of my questions, and Judge Harris, as he is often a step or two ahead of me. I was going to ask, what factual dissimilarity exists from this case to the SafePoint case that the trial court could possibly utilize to distinguish this case? Because I know of none as I sit here. I don't see how it's distinguishable. So tell me why I'm wrong.
No, I understand. And the only thing that I can say is that if the argument was never raised that forensic engineering language was ambiguous, then the court would not have addressed it. And we don't know in that SafePoint opinion, because the SafePoint court did not discuss that broad language of what forensic engineering is. That is the sole distinction I have. And I know Southern Oak came out after that. That was after our brief. That did say that. And obviously this court is not bound by the 3rd. But understanding that is the exact language. And I think it comes down to, is that forensic engineering definition so broad to take it outside of compliance with subsection 2A4?
And your position is it is?
Absolutely.
And my question is, what more would you require if you were writing it?
What type of engineering it is, perhaps? Because think about it. If there's something that hit the house, maybe a large tree or something, then maybe you're looking at a structural engineer. Maybe it's an electrical engineer.
Wouldn't the report give you that?
I don't know. That's the problem, though. The report is the actual work product.
Sure.
This is the estimate, and the statute talks about what the estimate is required to provide so that the consumer can understand what I'm assigning away and what you're going to do, you as the assignee, is what you are receiving for signing over these rights. And that's where the vagary comes in. Now,
Statute even require a definition? I mean, it's itemized per unit cost.
correct. It's itemized, right.
So that's the name of the service, the amount, and the price. So even if it just said engineer report with repair plan.
But that comes back to my question. And again, the third DCA said, yes, that is sufficient. That complies. They agree with that. But engineer report is such a broad term when you consider the definition contained within that same document. And that's where the ambiguity comes in with the estimate itself.
But in SafePoint, the identical language was found to meet the statute, right?
I'm sorry, I
In the
didn't.
SafePoint case, the identical language was found to satisfy the terms of the statute.
Correct.
And then you get to Southern Oak, judge there again dismissed it, finding it didn't comply, and the insurance company said, you know what, even though we argued for dismissal on appeal, we concede error. Third
Correct.
DCA accepted that argument and said, by the way, the fourth was right. We agree with the fourth. That language is fine. Why haven't you conceded error in this case? You got two DCA opinions now that say you're wrong.
Well, okay, so Southern Oak came out after our brief, and because SafePoint did
You're
not,
standing here today, you could say, you know what, Judge, there's two DCAs that say we're wrong. We concede error. Why are we here?
we're here because our request is that this court look at that forensic engineering definition in the estimate and say, this isn't enough based on that. I understand the third DCA quoted that language in its opinion. The fourth did not discuss it, and that's the distinction between those two cases. And because if Southern Oak had come out perhaps at a different time, I can't say, but the point is, that's the one case that's talking about the language that is so incredibly broad. And if the panel has nothing else, then we would ask that you would affirm.
All right, thank you. All right, just under 8.5 minutes.
I'll keep it shorter than that, Your Honor. The statute, 627.7152, only requires a written, itemized, per unit cost estimate. That's all it asks for. It doesn't ask for exorbitant definitions. It does not ask for everything to be boiled down. It just asks for those requirements. So looking at this assignment, looking at this estimate, it is written, and it sets forth what unit is being used, one report repair plan, the services being provided, the preparation of the report and repair plan, and the estimate, which is dated the exact same day and incorporated through specific reference. This court is hitting the nail on the head that we have two sister courts on identical facts that have ruled consistently the same way. And then finally, I ask the court to reverse the trial court, finding that the third and fourth are binding on them. Dismissal of this matter with prejudice was inappropriate, even under a potential tipsy coachman argument. I can, since I was the trial court counsel there, I can provide guidance on what was at the hearing, but the standard here is what's on the face of the order. And that's really where we're at. And because the order does not address any pre-suit demand, the court has to presume it wasn't addressed. We don't get to go outside of that. And so for dismissal, upholding a dismissal under tipsy coachman would also be in violation of the law. And I ask the court to reverse the trial court, and I thank you for your time.
All right, thank you. All right, our next case on the docket today is Flannery versus State of Florida, 24-3105. Again, counsel, 20 minutes per side. Appellant can reserve as much as you would like for rebuttal. We'll set it at 5 minutes, but if you want anything other than that, please just let me know. And whenever you're ready, you may proceed.
Good afternoon, Your Honors. My name is Trevor Milan. I am co-counsel who filed the notice on this case approximately on Monday. I'll be appearing for the appellant, Brian Flannery. Briefly, just to provide a factual basis on this issue, our client, Brian Flannery, attended a sentencing hearing that occurred on October 23rd of 2024. He was accused of a violation of probation on which he was serving a probationary period for a domestic violence strangulation charge. He was accused of picking up a new aggravated battery charge. Those are two third-degree felonies. Our counsel pled open to the court, and the sentencing hearing was conducted on October 23rd, 2024, for the purpose of having his sentence downward departed by the trial judge. So his score sheet had him at 43.5 months. Mr. Flannery was asking to be put on probation and house arrest, and he provided testimony through witnesses and medical expertise to try and
Sort of cut to the chase here. The ground for the downward departure that was requested by Flannery was .0026, was it to a mental disorder or physical disability?
Yes, Your Honor.
He claimed both.
Yes.
And he presented evidence supporting both.
Yes.
As part of that, isn't he required to also put on evidence to show that, a preponderance of the evidence, that his condition requires specialized treatment?
Judge, that is true as per the statute.
Here's the evidence.
The evidence was
Condition, either the mental one or the physical one, required any specialized treatment.
the testimony regarding the medical treatment was provided through witnesses who testified to his lack of ability to receive
Not the
proper
question. We get it. He's got physical issues.
Yes.
Where is the evidence? Preponderance of the evidence is what you're required to show that he needed specialized treatment because of those physical limitations or his mental condition.
Judge, in the transcript of the hearing, the
We've all read.
Yes, understood. The medical records were reviewed by the judge. Now, I understand that they were not introduced in the actual hearing, but the judge acknowledged them and reviewed them.
And they're not on the record on appeal in this case. And we don't have those reports from the two doctors.
That's correct.
So where is the evidence that Mr. Flannery was in need of specialized treatment, and just to jump ahead, that he was also amenable to that treatment? What evidence? I don't see those words anywhere in the transcript.
I understand that, Your Honor. There is case law that was provided in our motion, in my co-counsel's motion, that other factors other than what is specified in that statute can be considered.
Well, in sentencing, right, but in determining whether he met the criteria to qualify for downward departure, that's step one, right? It seems like all of the testimony surrounded that he would, it would be better for him to be at home, right, because of the risk of falls and his conditions, but that's not specialized. That would probably apply to anybody with a medical condition that's facing prison.
Understood. The case that I'm referring to is, I believe, Stevenson, which states that the trial court can impart a downward departure sentence for reasons not delineated in Section 921.0026, as long as the reason given is supported by competent substantial evidence and not otherwise prohibited.
But in this case, you're saying that the trial court below erred in not departing downward under that specific basis, right?
Yes, this case also provides another avenue that the judge should have considered in whether or not to downward depart. And our position is that the competent substantial evidence through the Stevenson case was provided through the testimony of the witnesses and the review of the medical record. That was
Competent evidence
discussed.
as to what?
Testified to his medical conditions, Your Honor.
Okay, let's say he's got that condition. Let's say that's not in dispute. Don't you need to prove 2 and 3?
Judge,
Specialized treatment, amenable to that treatment. Doesn't the statute say you need all 3? And if so, under the bank's analysis, how do we ever get past test 1 if you didn't prove it? Why do we even look at the second part?
Judge, I'll stand by the argument made in our motion. Our position is that Flannery satisfied all 3 prongs of that analysis through the medical reports of Dr. Kimball and Dr. Eiler and through the testimony of the witnesses at the hearing. That's our position on that matter.
Okay?
As previously stated, also in our motion, those assertions were not controverted by the state. The states provided evidence of the video of the new case when arguing to the judge that he should receive a sentence of 4 years rather than the 43.5 months. However, they did not provide any controverting testimony of these medical reports.
Is that as to the diagnoses?
That's as to their validity at all for the judge to consider before deciding whether or not to downward depart.
Could that be because he didn't present evidence of elements 2 and 3? So even if we accept that he's met the mental disorder that's not a substance abuse or addiction or a physical disability, that he doesn't qualify?
Again, it's our position that the testimony of the witnesses and the medical records support all 3 prongs rather than just the first. Your Honors, obviously the bank's controls here. Our position is that, the first element of banks, the trial court has to prove whether or not they could downward depart. It's our position that in considering that prong of banks, the trial court committed both procedural and substantive errors. First, I'll speak to the procedural errors that they committed. At the end of this hearing, in the transcript, the judge, it's our position, did not properly lay the record as to the consideration of whether or not he could downward depart. My co-counsel asked on the record in that hearing to specify if he could find whether or not he could. But the language that the judge used is more in line with the second prong of banks, whether or not he should downward depart, and with the abuse of discretion standard. So it's our position that the lack of clarity in the record.
You said at some point something like, I'm not going to make the findings that you want me to make. Or,
Yes.
And couldn't those findings be, again, amenable to treatment and need specialized treatment?
They could be.
Which would get you past the
They
first
could-
prong.
they
And he says,
certainly-
I'm not going to make those findings.
They-
Why?
they-
Because you didn't give him any evidence.
They could be, Your Honor, but that is, it is from just reading the record, it is hard to make that assumption, and that lack of clarity is a reason why this should be sent back down to be re-reviewed, in my position.
So are you saying if the trial judge, as I interpreted it, is saying, even if I found step 1, which he wasn't saying he did, then he would not exercise his discretion to downward depart? That would be reversible error, in your view?
In my view, the question of whether or not he should downward depart was not properly reached through the procedure. It's very possible that after reviewing everything as it's presented now, the judge could decide whether or not, with the abuse of discretion standard, he should downward depart. However, it's our position that we did not get to that point through the first leg of the bank's case. Your Honors, I'll briefly speak to some of the case law brought up in both of our brief as well as the state's brief, the Kowalski and the Camacho cases that were mentioned as both kind of using them, the argument of whether or not they were properly placed. I will just briefly mention that in Camacho, the second DCA determined that it was unclear based on the record what it was based on, rejecting the expert testimony, whether or not the trial court erroneously concluded the legal basis. But here in our case, our position is that the record was unclear. So in Camacho, they found that the record was clear. It's our position that our case distinguishes from Camacho, while the judge states that the finding about the disorder from Dr. Eiler is not one that he would consider. He doesn't apply that to Dr. Kimball's physical findings. Dr. Kimball being the orthopedic surgeon, he makes mention of the somatic disorder that he struggles with agreeing with based on his own review of the medical record. However, he doesn't make those specific findings as specifically to Dr. Kimball's physical findings of our client.
So you mentioned Kowalski. Isn't that distinguishable because there the DCA found that they couldn't tell whether the trial court had determined that it should not downward depart as opposed to being confined by the step 1 determination? And here he's saying, I'm not exercising my discretion or I'm declining to exercise discretion to downward depart, which is a step 2 analysis.
Right. So it's our position that in this Kowalski case, Your Honor, that this would be different because the step one of the departure analysis did not take place in our case, distinguishable from the Kowalski case. Your Honors, at this time, if there are no other questions, I will reserve the rest of my time for rebuttal, and I appreciate your time this afternoon. Thank you.
Thank you.
Good afternoon, Kurt Kohler on behalf of the state of Florida. I just have a couple points to make here, starting with the first step in the Banks analysis, whether there was competent substantial evidence of each of the prongs of the 2D departure for specialized treatment. There's no evidence in this case of specialized treatment, of a need for specialized treatment. There's no evidence that he would be amenable to specialized treatment. Both of the doctor's reports, Dr. Kimball and Dr. Eiler, are not in the appellate record. They're not in the trial record. They were apparently just given to the trial court judge kind of in an in-camera manner, but that is not sufficient to put into the trial court record, and the court cannot consider them for that reason. So that's point one. Point two is under the analysis for discretion. The trial court was very clear that it was using its discretion the entire time. It started out as soon as it was questioned by co-counsel for the appellant that it was exercising its discretion. It never really deviated from that. So you can really look at this as an even-if situation. He's saying, even if there are grounds to depart, I'm exercising my discretion not to depart. So that's the state's position. We believe that Kowalski is distinguishable, again, for the reasons the court has stated. The court in Kowalski didn't mention discretion until the 3800 hearing. So by that point, it hadn't mentioned it in the initial sentencing hearing. So that's one reason it's distinguishable, and the second reason for Kowalski being distinguishable is that there was evidence for specialized treatment in that case, and there was evidence that he was amenable to that specialized treatment. The second case, Camacho, similar situation. The trial court in that case did not use the word discretion in its ruling. It just said that he wasn't eligible for a downward departure, I believe. So
To properly exercise that discretion, does the trial court need to complete that step one analysis, or is it enough to just say, even if he does?
It doesn't really need to under cases that were not cited in our briefs, so I can't really talk about them. There's a lot of recent developments in this area of law that have been going on in the first DCA, I believe. So I can't really get into that, but yes, the state's position is that the court really doesn't need to go through that first step analysis like in a bullet point way. It can do it in its head. It doesn't have to state it on the record. It can say, you know what, even if the evidence is there, even if there's competent substantial evidence for these grounds for departure, the court is exercising its discretion not to depart.
In other words, your position on behalf of the people of the state of Florida is the court must conduct the analysis, but you must not recite any magic words in order then for the decision to be upheld.
Right, and I think that's
That would
consistent.
be form over substance, would it not?
Yeah, that's consistent with case law in just about any situation where you have the court ruling on the record. There's no magic words.
And it's part of that because the trial court said, I've considered the reports of the doctors, I've considered the evidence, so even
Right.
having heard the evidence of the condition of the defendant, it still shows that that didn't outweigh the conduct and decline to downward depart.
Absolutely correct. And if the court has no further questions, the state would ask for the court to affirm the judgment in all respects.
Thank you. All right, counsel, you've got about 9.5 minutes remaining.
Not be taking that much time, Your Honor. And I appreciate all the time you've taken already. Your Honors, we will just abide by the arguments in our brief. It's our position that the trial court erred in not conducting a proper Panks analysis. I understand that there are no magic words that need to be read into the record. However, based on the lack of clarity in the record, we would ask that you reverse and remand this back down for further consideration. And if there are no questions, I will cede the rest of my time. Thank you.
All right. Thank you both. All right, our third, final case on the docket today, case number 25-115, Ishmael Cruz versus State of Florida. See, it's not scheduled till 2 o'clock. Is everybody ready to get started? We're a little bit. You got it. Okay, 20 minutes per side. Appellant, we're going to reserve 5 minutes for rebuttal for you. If you want anything other than that, please just let me know and we'll make that arrangement.
5 minutes is good.
Okay?
May it please the court, Laura Sapiro on behalf of appellant Ishmael Cruz. I just want to start off by pointing out that in this case, the appellate judge did not have the opportunity to view, the trial judge did not have the opportunity to view the video at the time he initially made his decision. The video was discovered later on. The judge reconsidered it, but...
Came back on rehearing, right?
Yes, and
And then
rehearing.
you did see the video.
Yes. But regardless, under the Howard case, this court is in the same position to review the video as the trial court. And I
But
want
not
to
evaluate the credibility of the trooper, right?
not to evaluate the credibility of the trooper, but comparing his testimony to discrepancies in the video. And I think there are quite a few that are important to point out. The trooper describes continuous swerving, and I think the video shows at best drifting. I don't think it's continuous. To me, swerving implies jerky, quick movements back and forth, and that's not present in this video. The officer also testified that there is a point where there's a curve in the road, a left-hand curve in the road, and he makes a very wide turn and then ends up in the right lane. That's not supported by the video. There's no point where the driver goes into the far right lane.
You say he went all the way into the far right lane, or he just crossed tires into that?
To me, it sounds like he says he changed lanes, so went into I would say went into the right lane and continued in the right lane for several intersections.
Didn't the trial court offer for the trooper to be cross-examined now that the video had come to light and no request for an actual second evidentiary hearing was ever made?
That's my understanding based on the record, yes.
Why not?
I can't really speak for the trial attorney. I think the trial attorney probably suspected that the video speaks volumes, which I have to agree it does. I think these discrepancies are quite significant. On top of that, he says that they never stopped at any red light. There is a red light in the beginning, and the driver stopped safely. There's no evidence of impairment in that action. I'm sorry, I thought I heard something. When they were stopped and we hear the trooper over the radio, he goes and he talks to the driver, he gets his information, he comes back, and the other officer says, "Do you think this is DUI?" He says, "No, I don't think so. He seems fine. I don't smell alcohol." But then at the hearing, he testifies he smelled an odor of distinct alcohol impurities emitting from the vehicle when he first approached. That's not true. When we look at the field sobriety exercises, during the 9-step turn, he says that he had to remind Cruz to count out loud. The video doesn't show that either. It shows Mr. Cruz counting from the beginning. Also during that exercise, he says that on the 3rd step of the 2nd series that he didn't step heel to toe. I think it's pretty clear in the video that he did. He also says
Let's do
that...
these one at a time. Because you got the stop, then you got the test, then you got the arrest. What's your challenge to the actual stop?
To me,
You said he wasn't swerving because the officer said... It was within the lane, which is that's a ground to make a stop, right?
It could, but my position is based on the video. It was not swerving. Swerving definitely exaggerates what was going on.
But it was
there.
bouncing back and forth, and he followed him for 3 miles. I mean, a lot of times in some of the cases, you'll see how erratic was the driving, how long were they following for, was it consistent enough for a reasonable officer to say, you know what, I think something's going on here. I don't know whether it's criminal conduct or not, but it's enough for me to say, I think we need to do a welfare check.
Well, I think that I don't think it's enough for a welfare check, and I think we kind of have gotten to the point in some cases where we're kind of using a welfare check to circumvent the Fourth Amendment. If we look at the Levy case, which I had filed supplemental authority on that just recently came out, says because searches and seizures conducted in connection with welfare checks are solely for safety reasons, the scope of an encounter associated with a welfare check is limited to prevent the exception from becoming an investigative tool that circumvents the Fourth Amendment. So I don't think the officer can follow him for 3 miles, think, I don't have enough for reasonable suspicion or probable cause or whatever it may be, but let me just do a welfare check and see.
Well, let's not go with whatever it may be. Is it probable cause or is it reasonable suspicion?
My position is that under Wren, that's controlling. We're required to go by what the U.S. Supreme Court says, and Wren says probable cause. I understand that this court and some other courts have maybe suggested otherwise, but my position is that it's
Every other
probable.
court in Florida? All
I
the other
apologize?
DCAs and the Supreme Court?
I believe there was a recent case in the 68 DCA that did not, that came to
Made
the,
it clear reasonable suspicion is all that's needed to make a stop, right?
I'm sorry, say that again?
We've made it clear that, at
This
least in this
court has.
district, reasonable suspicion is all you need, which is much lower than probable cause.
Yes, I agree.
This trooper did not have reasonable suspicion that something might be going on with this driver based on the pattern that he described?
No, I don't think it met the pattern of erratic behavior or of impairment. In fact, the officer testified, the defense attorney went over the 24 clues of impairment, and he said he didn't see a single one.
Did he? So I looked at that language. He says, aren't there 24 signs of impaired driving? And then he goes through and names maybe 8, like sudden stopping, and he asks the questions, and the officer says, no, that wasn't present. Does the officer ever say, no, I never saw any sign of impairment or any cause for concern?
I don't think he never saw any sign of impairment. I think the way he answered the question was of those 24 clues that were taught about. In his opinion, what he calls swerving, continuous swerving, he sees that as a sign of impairment, but I don't think he answered it as to the 24 clues. I believe he said he didn't see those. He also conceded that he was driving the appropriate speed. Excuse me one second. He even indicated in his report that he did not think that Mr. Cruz was impaired by alcohol. And again, he went back to his officer and said, I don't think so. I think if we look at some of the cases that I cited in the brief, if we look at Erred, Jordan, and Crooks, granted they did kind of allege a violation of the traffic statute. I think that these they discuss that there wasn't, for example, in Erred, nothing in the record to establish that his actions were not done safely or that they would, quote, lead a reasonable officer to suspect impairment, which would be considered erratic driving. In that case, it was failure to maintain a single lane. He crossed over the white line from the far left lane into the right lane without warning or without turning signal. There were no other cars nearby. And he did speed up and then drive slow, which was one of the 24 signs of impairment. In Jordan, it was the same, failure to maintain a single lane. And they used the term swerved. I don't know based on the video. I haven't been able to see the video, but swerved for no apparent reason. There was no evidence that anyone else was in danger. And there was no testimony that the defendant was intoxicated or otherwise impaired, or that there was any erratic pattern behavior. And I think it's the same things in Crooks, where they didn't claim that the maneuver endangered anybody. There was no testimony that the car moved a great distance over the line, simply that the car drifted over the line twice, and there was no testimony as to how far. And I think in this case, granted I don't have the best eyesight, I can't really see how far it went over, and I don't think the officer testified inches, feet, or whatever. Excuse me. I want to move on to...
Yeah, let's just say in this case that the stop was justified. Is that the end of your case?
No, no, the next step would be whether he was justified in initiating the DUI investigation, but I first would like to focus on the arrest. He had him
Client
do,
gave his driver's license.
sorry?
Your client gave his driver's license to the
Correct.
trooper. A quick search revealed he's driving on a suspended license for 7 years or whatever. So he's arrestable at that point, right?
Yes, he is,
Pull him out of the car.
yes.
He
But
pulls
if
him out of the
there's
car,
evidence
he-
that he knew his license was suspended,
He pulls him out of the car. He again smells alcohol in his breath.
correct.
Then we get into the DUI investigation, the FSEs.
Yes, and I believe that the FSCs, again, there's, as I mentioned before, there's some discrepancies which show that with the FSEs, he didn't perform as poorly as the officer testified to. For example,
For us to determine or for the trial judge?
well, I think you're in the same position because you're able to view the video. I mean, granted, the trial judge can determine the officer's credibility, but I think we can see some pretty clear discrepancies on the video.
But let's say we could say, okay, he said he found, and I don't remember the number of signs of impairment, but let's say he found 9 signs of impairment. And from the video, we can say, I don't know if I agree with those 2. Isn't it still a totality of the circumstances, performance on FSEs, plus the driving pattern, plus the odor of alcohol, plus I believe he also had the watery eyes, flushed face, and it's a totality of the circumstances test. Why wouldn't that be sufficient?
Well, I think it is a totality of circumstances test, although I don't think that those added together with the FSEs necessarily add up to probable cause to arrest. I know that it's a county court case, the State versus Leberque, but in that case, the officer didn't observe erratic driving, even though he was driving his motorcycle down the wrong side of the highway. The defendant was slow to dismount his motorcycle, and the officer detected alcohol upon approaching him, which grew stronger as he got closer. He had difficulty getting his license and registration, was fumbling. We don't have that in this case. And he was swaying a little bit, but not a hard sway. And then during the field sobriety exercises, again, he was swaying. He did mention that he had some pain and stiffness in his joints due to gout. And in this case, the defendant here had military-related injuries related to his ability to balance.
In this case, we do have some evidence of difficulty in presenting a license and registration, right? He fumbled with it or something?
Well, initially, on direct, the officer testified that he did not have any difficulty in,
What's in the AIR?
sorry?
What's in the AIR report?
The ARI report does check the box for that, but the officer testified to otherwise. I think on the video, it's kind of hard to see, but there's about 50 seconds between the time that the officer says, "Can I get your documents?" and between the time the officer walks back to the video, but we can't see what's going on in the car. He may have had it in 10 seconds and then waited for the
Also,
officer.
there's also an admission of drinking before the
Yes.
stop.
Yes, there is, but drinking and driving on its own isn't necessarily a crime. You have to be intoxicated to the
Under
intent that
the
you're...
totality of the circumstances, that's something else that the trooper could factor in.
Yes, it's a factor that he can take into consideration. But I just think that based on the facts in this case, the discrepancies in the video, another discrepancy that I don't think I mentioned, excuse me. For example, on the finger to the tip of his nose, the officer says on the last set, he paused with his left hand for 3 seconds and had to be reminded to take his hand down, and he did the same with the right hand. That's not in the video. He doesn't remind him of that. Granted, he does wobble at certain times. Again, he's got balance issues. Apparently, the officer thought that the balance issues, in a way, watered down or maybe even negated some of the tests because he understood that he had an injury related to that. And I think unless this court has any more questions, I would yield my time for rebuttal.
Okay?
May it please the court, Sam Prone for the state. To be honest, Your Honors, I don't have anything to add to what Your Honors have already questioned counsel about and what we've argued in our answer brief. So the state would like to rely on our answer brief if you have no further questions for me.
Okay. Thank you very much.
Thank you.
I would just, again, Your Honors, I would just point out again that, yes, he followed him for 3 miles and saw some drifting. I, again, argue that it's not continuous. It's certainly not swerving. And during that 3 miles, which is a significant amount of time, he didn't notice, again, any of the 24 signs of impairment. In this case, I don't think that they can.
Can you explain to me, like, where in the testimony he said, I don't see any?
Yes. I believe the question that was posed to him, which granted was on cross and was a little bit of one of those negatives followed by right, correct.
Right, because I recall the question is, aren't there something like 24 signs of impaired driving? And he says, yes. And then he says, did you see? And my recollection is it's something like 5 or 6 that he goes through, and the officer says, no, he didn't see those. But does he say, I never saw any sign? Because that contradicts, on the probable cause discussion, he combined in his decision to make the arrest, including the driving pattern.
Yes, so I think it was more like around 12 that he asked about. And I believe it's on page 456 through 458, towards the end of that, which would be 95 through 97 of the transcript. He does make a comment to the effect of, based on, let me pull it up here. I want to give you the exact citation or the exact quote. So on page 97 of the transcript, which is 458 of the record. All right, it's on line 15. All right, none of these things you witnessed, right, during the time of your 3 mile, approximately 3 driving pattern, correct? And he said, yes, sir. So I would argue that at the very least, the 12 or so that he referenced, the officer acknowledged that he didn't witness any of those. Unless this court has any further questions, I will mention.
Okay, thank you all very much.
Thank you.
All right, that is the conclusion of this afternoon's docket. At this time, the court will stand in recess, and you're all excused.